Good morning. It's time for us to begin, and we have a quorum. First of all, let's invite the administration in, please. Good morning. The last meeting was held on the 6th of July, and as you recall, we have already finished scrutinizing the examination of clauses of the Property Management Services Bill, and members raised some comments during the last meeting. And we had two main areas of concern. The administration had already given a written response, which is paper CB brackets 286-1516 brackets 01. In a moment, I will invite Mr. Franco Kwok, Assistant Director of Home Affairs, to brief us on that. And during the clause-by-clause examination, members had raised comments on different parts of the bill. The Secretariat has also spent quite some time in coming up with a summary. And we are looking at LC paper number CB brackets 286-15-16 brackets 04. And this is for members' reference. It has been circulated already. And as for the committee stage amendments moved by the administration, and it's listed in LC paper number CB brackets 286-15-16 brackets 03. Since the paper was only provided yesterday, since there are a number of amendments, I believe members might need some time to go over them. With regards to the bill proper, perhaps I would invite Mr. Kwok, Assistant Director of Home Affairs, to brief us on the administration's response. So can Mr. Kwok walk us through the administration's response, please? Good morning. First of all, on the issues raised by members during the last meeting, we have already provided a written response. So let me quickly brief members on that. Last time, the members raised comments on the drafting of Clause 46 on the disclosable interest, and this is on the disclosure of interest stipulated by the Property Management Services Authority, or PMSA. If a member of the PMSA has a disclosable interest in any matter under discussion at a meeting of the PMSA, then the member must disclose the nature of the interest at the meeting, and the disclosure must be recorded in the minutes of the meeting. We feel that the definition of disclosable interest in Clause 46 brackets A of the bill has included all actual or potential interests. And the present drafting of the clause has already fully reflected our legislative intents. And with regards to the Chinese rendition of disclosable interests, we have already taken reference to provisions in other legislations such as competition ordinance and estate agents ordinance, and we felt that the Chinese should be rendered as 應披露利害關係. And if and under clause 46 brackets 1, disclosable interest is defined as a personal interest greater than that which a person has as a member of the public. These may include interpersonal relationships such as spouse, relatives, friends, etc., or individual members' relationship with other relevant organizations or institutes. And a similar requirement is also found in other legislations, such as the Competition Ordinance and the Communications Authority Ordinance. So that's all for my part. Thank you very much. Do members have any follow-up questions on the administration's response? If not, can Mr. Kwok also walk us through paper number 03? Chairman, I'd like to follow up on the paper Mr. Kwok just mentioned on the disclosable interests. And he just cited a few examples. For example, colleagues or business affiliates. Are there any specific guidelines? As a public officer, it's normal that you are acquainted with a lot of people and you have to disclose the people you know. Is that the case? I don't really fully grasp what you just said. Mr. Kwok. Under clause 46 of the bill, disclosable interests refers to personal interests. So I cited some examples of interpersonal relationship like relatives, friends, and so on. And disclosable interests only also exists if a member of the PMSA is a member of some academic societies. So the PMSA can issue guidelines for members' reference in the future. Any follow-up questions? Anything else from other members? If not, can Mr. Kwok walk us through paper 03, please? After 14 Bills Committee meetings, members have raised a lot of comments, and after consolidating all these comments, we have provided draft committee stage amendments, and they are listed in CB brackets 286/15 to 16 brackets 03. We have a lot of draft amendments, and we have spent considerable time coming up with this summary. If members did not have the time to go through all of them, I'm happy to go through them with members. So I would try to explain these amendments one by one. Right. First of all, Clause 2, which is the definition of company in the English text. This is a textual amendment in response to members and the assistant legal advisor's suggestion to align the English and Chinese texts. Members, as I said, the government only provided the paper very recently, and there are a lot of CSAs involved. If members have no major objections, we can focus on the first two clauses today. For the remaining clauses, we might need more time, and the next meeting will be held on the 10th of November. And in the next meeting, we would have more time to scrutinize the CSAs moved by the government. And we can see whether we have other comments. As for today, if there are no objections from the members, we should focus on Clause 2 and Clause 4. So you can take a good look at these two clauses first. This meeting is was intended to finish 2 hours later, and we might not have enough time to scrutinize all the clauses or to understand everything submitted by the government. So any comments from members? Mr. Wong Ko-heng. Chairman, I welcome your decision, and at the same time, I think the administration should provide a paper outlining the reasons for not accepting our comments. They should list out the reasons so we can follow up. So it has been a few months since the last meeting in July. Should the government list out the reasons for not accepting our comments? I'm sure the government has considered members' comments and moved amendments accordingly. Members might not have time to read the paper yet. So, Mr. Kwok, any response? Thank you very much for the comment of Mr. Wong. And over the last 10 or so meetings, the Secretariat has come up with a summary of our response, which is LC paper number CB-286/1516-04. And the administration's response in the past was summarized. And as for the committee stage amendments, once members' comments are accepted, we would elaborate on that. And we can further update this paper because certain CSAs have been revised. So we can update this paper. We have already taken a lot of members' comments on board, as you can see, and I can highlight the main CSAs in response to members' comments.
All right, if we have time, we can certainly take a look at it again. I have read it myself. The Secretariat has also confirmed that the government has already responded to those points. I agree with your proposed arrangement, Chairman. I am particularly concerned about certain changes the government has proposed in the paper. I wonder whether I can also ask some questions at this stage, or should we follow your proposal that we should only concentrate on, items 1 and 2? I have read the paper and I have some questions that I would like to immediately put to the government. Well, I don't think there's any problem with that, but today, since the government has come up with many CSAs, and we may need to look at the amendments, including the amended text. Of course, we can certainly raise questions, but like Mr. Kwok said, if there are important issues which members are very concerned about, then Mr. Kwok can certainly explain, and we can certainly do it this morning. But regarding the textual amendments, details regarding the terminologies, I think we can save them for the next meeting. So if members are agreeable to that arrangement, then I think we can proceed accordingly. All right? Mr. Uchiwai. Thank you. First of all, different members are certainly entitled to ask different questions. I agree that the paper only came to us yesterday. Indeed, we need time to digest the what is in the paper and cross-reference that with what we discussed earlier. So I'm inclined to agree that we should only finish our scrutiny of the first two clauses and then adjourn for the time being. Of course, members can certainly make other inquiries with the government. But basically, I think we should first, deal with those two clauses. And so I'm inclined to support your suggestion that we should finish the two clauses and then we can adjourn and then discuss the rest of the amendments at the next meeting. We might be repeating some of the points, but still the government would be making the responses. Mr. Kwok, is there anything that you'd like to highlight in particular regarding the whole package of amendments so that members can go back and focus their attention on those parts? And I'm sure this would help, us to have a smooth discussion at the next meeting. Chairman. There are 40-odd amendments in the paper. Many of them are technical in nature or only textual amendments. There are basically three major amendments which are responses to concerns raised by members. First of all, in Clause 7, for the OCs who manage their own properties, they are exempted from having to obtain a license. Members in previous discussion were concerned that if this were allowed, it would, create difficulties for property management. Having heard members' comments, we've also noticed that during the consultative stage, many properties which are self-managed by owners, even after the passage of this bill, their self-management of the property will not be affected. In order to strike a balance, we are proposing an amendment in the bill that is for self-managed properties. If the number of units exceed 1,500, then such properties cannot be managed on a self-managed basis. So this will ensure that properties which are self-managed by owners at the moment will not be affected by the passage of the bill, and they can continue to manage their own properties in this way. If the number of units exceed that number, then of course they shouldn't be allowed to continue. Another concern was whether or not some OCs will, with the passage of this bill, dismiss the property manager and then manage their own properties instead. Having considered this point, we are prepared to make an amendment. That is, if the OCs at the moment are already engaging PMCs, and if they want to change the property into the self-managed mode, and if the number of units do not exceed 1,500, then they will need to pass a resolution at an owners' meeting before they can adopt the self-managed mode. The third major amendment is in respect of the license renewal of PMCs. In Clause 10, it is stipulated that the licensee may, 2 months before the expiry of the license, apply for renewal. Members are concerned whether or not that would be enough, and that the license holder, if they were late in the application, would they still be able to have the license renewed. We have looked into this further, and in order that the licensee will have sufficient time to apply for license renewal, and that we have enough time to deal with the application, and just in case the application were not approved, we want to minimize the impact on the properties which are managed by the applicant. We want to do something to ensure there is better protection for all parties. So we're now proposing that the PMC, the license holder that is, may, before the 6 to 9 months before the expiry of the license, can apply for renewal. In respect of a licensee who's a person, he can apply 3 to 6 months before expiry, so long as the application were made during the stipulated period. Even though the authority may not be able to complete the license procedure renewal in time, then the license will still be deemed to be valid before renewal is made. If the authority is satisfied that an applicant has good reasons to be late in the application, they may still process the application, so that when the license expired and the authority has not yet completed the process, then the license may continue. That is, the authority will have the discretion to extend the license for 6 months, in this case with conditions attached, or the authority may charge a fee of the applicant so that the license could be extended for 6 months. Same for the licensee who is a person. And if the authority cannot process the application by the PMC within 6 months, it has a duty to inform the owners of the properties managed by the PMC that the company has not made an application for a license renewal, so that the owners may know whether the PMC has forgotten to apply for renewal or it does not intend to continue with its service, so that the owners can find a replacement. If eventually the authority decides not to renew the license of the PMC, then we have provided for a new mechanism. That is, the authority may extend the license of the existing PMC for 6 months, so that the properties that they are managing will have sufficient time to come up with arrangements to engage a different PMC in replacement. Of course, that discretion, for the exercise of such a discretion, the authority may charge a fee. So these are the 3 major amendments that we are proposing. In the paper, you would also notice that members are also concerned about clauses 35, that is the question about exemption, and also the avoidance of self-incrimination. So during the course of investigation, there should be such exceptions and privileges. But during the hearings and appeals of the authority, such exemptions and privileges should also be allowed. We're still discussing with the DOJ, and at the appropriate time, we will inform members of our final amendments. Do members have any questions regarding what Mr. Kwok has just reported? Of course, we welcome the government's proposed amendments. Many members are concerned about the question of self-management, especially for 4B. You are proposing the threshold be set at 1,500 units. How do you define unit? Does that include car parks? So what exactly does unit refer to? Mr. Kwok. Thank you, Mr. Chen. I believe Mr. Chen is referring to 7.4 bracket A, both 4A and 4B. I think the amendment proposed that in any property with more than 1,500 units, according to the BMO, I think the exemptions will not apply to these properties. The term unit actually, follows the definition in the BMO. If you look at Cap 344 and the definition of unit in that ordinance, the unit refers to any premises, whether it's described as a unit, whether or not the premises is a domestic unit, a shop, a factory, so on. If the owners are entitled to enjoy the exclusive management of the property. In other words, there would be, divided shares other than the common parts, and the owners are entitled to enjoy the use of such premises. That would satisfy the definition. Of course, it would also depend on how the DMC is drafted. And right now, car parks also enjoy a number of undivided shares. So in this case, units will also count under the definition of unit. So it depends really on how it is defined in DMC. Mr. Chen, well, that's very clear. You would define unit according to the number of undivided shares as defined in the DMC. My second question is this. So if you allow the OCs to engage a single company to take care of the security service or the cleansing services, or further subdivide the management services, then can they evade the requirements of the law and do not have to engage a PMC? According to the proposal in the bill, if the company only provides for a single service, it doesn't need to obtain a license. But if the OC had already engaged a PMC previously, of course, with the amendment, then the OC must have first, carried out an owners meeting before they can dispense with the employment of a PMC. And in which case the OC may provide for comprehensive property management services. If you see people, trying to make use of the loopholes, you will still intervene. So I'd like the government to put on record how you intend to enforce this ordinance, because people have ways to come up with loopholes. You say that, well, we're concerned that if the OC only engage a company providing a single service, we want to ensure that the loophole will not be exploited. They have a company at the same, if the OC has to find an agent to provide cleansing service and security services, they will be bound by the requirements of this bill.
Yeah. Mr. Wu Chi-wai, Deputy Chairman. I have 2 points to make. First of all, I welcome the provisions under the bill on self-management, and a decision can only be made after consulting the owners at the owners' meeting. And on the issues of concern, and in terms of property management, we have to follow the buildings management ordinance and the deed of mutual covenants. And these two sets of regulations should be introduced to the bill. And since we follow these two sets of rules, which all property management companies have to follow, and they form an important basis of the bill. If we can introduce them into the principle or the main legislation, then we can better educate and supervise or monitor. Right now, under the bill, the penalties are rather indirect. So my question is that in terms of property management, why aren't these two sets of regulations be included in the main legislation? You said you would follow the code of conducts. Although in effect, by following the code of conduct, it's the same as following the primary legislation, but would you take reference from other legislations in setting up the bill so that all monitored companies or practitioners would have a better idea of what they have to do? Mr. Kwok, anything in response? In past meetings, we've already explained that property management companies have to play by the law. Even without this bill, they have to abide by the law of Hong Kong. And as a party in the deed of mutual covenant, they have to abide by the deed as well. And under Cap 344, owners corporations are regulated rather than property management companies. So the PMCs help manage the building with the owners corporation according to Cap 344. If we are to introduce a relevant provision from Cap 344 into this bill, we don't feel it's necessary because the PMCs have to follow all the rules, including the Buildings Management Ordinance, Fire Ordinance, and so on. So it's impossible for us to expressly include all the provisions, and our norm is to ask the PMCs to abide by all relevant laws. And it's not our practice to list them out one by one. Sometimes PMCs are put in a difficult position, and they might be asked to do something outside of Cap 344. So as such, the PMCs and licensed officers have to help the owners abide by the law. And the licensee can report to the PMSA if they have been, if they were asked by the owners committee to do something illegal. And this would provide for an excuse in case of any potential disputes. And hopefully this can achieve what Mr. Wuchiwai has in mind. And through public education, we can further educate the owners' corporations on the roles of themselves and the PMCs. We have to consider the actual legal effects of the bill. So we feel that the present drafting of the bill can satisfy the concerns of Mr. Wuchiwai. Apparently, the government has raised 2 points. The first is that it's unnecessary to do anything extra. And second, in the drafting of the bill, if I understand correctly, this might not be an appropriate measure. No, he said the PMCs have to play by the law. So are there any downfalls of including the relevant provisions? If there are no downfalls, and if it helps, if it helps educate the public and facilitate our work, I don't see any reason they cannot be included in the primary legislation. at the end of the day, property management companies face a lot of issues, and this is irrelevant to the primary legislation, in fact. If we can enhance the impacts of the bill, barring any downfalls, I don't see any reason why we shouldn't do it. And if there are any issues, please let me know. Members, Mr. Ip Kwok Him would like to ask a question, so I have to manage the time. 5 minutes each, please. Mr. Kwok, you have 5 minutes to address Mr. Wu's concern. Should we include the provisions in the law or enhance the existing guidelines to raise awareness on the requirements listed in the DMCs? Are there any disadvantages if we include the provisions in the main legislation? Chairman, as I explained, in general, everyone has to follow the law, and if the licensee has to follow Cap 344, doesn't mean they do not have to abide by other laws, and it's very difficult to include all the provisions in an express manner, and it's in many cases it's impossible, and that's not our general practice. And we have to consider the actual impacts if we include those provisions. If we want to help the OCs or owners abide by Cap 344, well, that's just one area of work by the owners, and the main legislation would have been very, very long. If we are to amend it in the future, it will be very difficult. So our recommendation is that the code of conduct is adequate, because the licensees would have to help the owners or OCs abide by the law. We don't have to include it in the main legislation. Chairman, I think property management is different from other ordinances, and the biggest controversy is whether we have to follow the building management ordinance or the DMC. And we have seen a lot of arguments in the past. And I'm sure colleagues who are involved in property management would understand the possible issues. There are a lot of gray areas. So the purpose of this bill is to enhance the building management ordinance and the DMC. So the two most important sets of regulations should be followed by property management companies, which include Cap 344 of the BMO and the DMCs. And they have to follow the code of conduct as well. So that's my opinion. The government has to understand its priorities. You cannot simply tell us that the bill would have been very, very long, because these are important areas of concern. If the government is not willing to do anything, I will take it on board. Mr. Kwok, I understand the issues faced by Mr. Wu in the past. But in CAP 344 of the PMO or DMCs, the main parties are the owners and OCs, and the PMCs merely have a supporting role. And we have to consider the actual legal impacts. Mr. Wu said he would come up with his own suggestions. If there are specific suggestions, we are happy to look into that with Mr. Wu, and we can see whether these recommendations are appropriate. But at this stage, I don't see how it's appropriate to include those provisions in this bill. Well, if that's the case, you would face the same issues even if you follow the Code of Conduct. You said it's okay to include them in the Code of Conduct, but not the main legislation, since the targets are different. But by the same token, it's inappropriate to include them in the Code of Conduct. I think he has heard your view, and you can have discussion among yourself to deal with it. Mr. Ip Kwok Him. Now I finally understand what Mr. Wu said. So Mr. Wu wants to include certain provisions under BMO CAP 344 and DMCs. Why aren't BMO CAP 344 and DMCs mentioned in the main legislation? I agree with this principle. If PMCs or OCs do not follow CAP 344 of the BMO or DMCs, how can the government enforce the law? But I understand, but I agree with the government that it does not have to be stipulated, because it's obvious that they have to follow the law, and PMCs have to be familiar with CAP 344 of the BMO before they can carry out their work. But what about the Code of Conduct? It's merely a set of guidelines, so it's different from the main legislation. So I don't see a need to do so. But if Mr. Wu feels it's necessary, then go ahead and do it. I agree with Mr. Kwok that we have to follow the CAP 333 of BMO and DMCs. But it's rare. It's uncommon to have a bill to explain another bill. And for the CSAs moved by the administration, I agree with the 2 points mentioned, because they have taken our comments on board. But the fact is, I didn't have enough time to look into the details. The first part of the paper stipulated the reasons for amendments, and part 2 are the actual amendments. Part B is the marked up copy. I agree with the chairman's decision to allow the administration to explain the amendments. But next time, can we focus on a single paper, and that would be easier for us. The amendments might be listed in Annex A, and perhaps next time we can look at the marked up copy for simplicity's sake.
Which document will you be using as reference as we scrutinize the proposed amendments? I think we've already are at the stage of looking at the CSAs. So personally, I think we should refer to Annex B, the marked up copy, as we, scrutinize each of the amendments. I think that would be more efficient. So I think we need to, go through each one of these one by one at the next meeting. Thank you. Well, my preliminary thinking is that we've already concluded the clause-by-clause scrutiny of the bill, and all the points raised by members have already been summarized in the table, and the government has already responded to those comments. So Annexes A and B are both in English and Chinese, and in the past we always would start by looking at the Chinese version. Of course, there might be some amendments which are made in response to suggestions by our legal advisor. So when we look at Annex A, we may also need to cross-reference Annex B, depending on the section or clause. If time allows, then today we can first look at amendments to clauses 2 and 4. I made this suggestion because these are relatively simple suggestions made by our legal advisor. And they're only technical amendments or terminological amendments to further clarify the requirements of the bill. So I think that's the simpler part. But for the rest of the amendments, I think members may need to time to scrutinize them one by one. And that is why at our meeting today, we will not be looking at the other amendments. So that's my proposal. But if members have other views, I'll be happy to listen. Before I allow Ms. Sterry to speak, I would like to give some time for Mr. Kwok to respond. Mr. Kwok, do you have any response to the points raised by Mr. Kwok Him? Thank you, Chairman. I'd like to thank Mr. Yip for his suggestions relating to Mr. Wuchiwai's comments. I agree with Mr. Yip. I see no need to incorporate what Mr. Wu suggested into the bill, but we can put it in the COP because it is the duty of the license holder to comply with the COP, and it is only one of his responsibilities. If we were to exhaust all the responsibilities he needs to bear in the principal legislation, that legislation will be very long, and I don't think that is the best way to deal with the principal legislation. I think we can leave it to the authority to decide on how to address that issue. So I see no reason for the time being to incorporate the proposal made by Mr. Wuchiwai, Chairman. I think it's better for us to refer to Annex B, the marked up copy. Okay, thank you very much. Mr. Riley, Chairman. Well, I had gone to another meeting just now, and I'd like to now ask a question. We are now given these new proposed new amendments. For example, the threshold of 1,500 units. If the number of units exceed 1,500, self-management will not be allowed, and also the timetable. I'd like to know whether or not you've consulted with the industry regarding these proposed amendments. Thank you. Regarding the first one, that is the threshold of 1,500 units. That has responded to concerns expressed by members, and also during previous consultation, properties which are self-managed. I think we've already obtained some inputs from the owners, and our proposed amendment has struck a balance amongst those different views already. The second point is about license renewal. At the moment, our proposed procedure for license renewal is a lot clearer than what was originally proposed in the bill. So the PMC would know how to apply or renew the license, and better safeguards are given to owners. Thank you. Right. Regarding the amendments proposed by the government, Mr. Yip said that we should, refer to Annex B as we go through these amendments, and I agree. Mr. Kwok, are you agreeable to that? All right. So I don't think we need to look at the English version. I think we can only need to look at the Chinese version of the marked up copy, unless terminologies. I think if members don't mind, I think we may also take a look at the English version because we want to ensure consistency between the two versions. So, well, in the past, as we scrutinize different bills, basically we would be relying mainly on the Chinese version, and we'll ask our legal advisor to take some time to look at the English version for us. And if there's any points that he wishes to raise, then we can follow up on those points and consider them at this meeting. So I don't think there's any problem with that arrangement. So as agreed, could we now ask Mr. Kwok to briefly walk us through Clause 2, the proposed amendments to Clause 2. Thank you. Looking at Annex B, Clause 2, basically this is a proposed amendment to the English version to align them with the Chinese version of the bill. Basically, we are proposing to remove the word or otherwise and replace them, and use the word and to replace all, so that the Chinese and English versions are now aligned with each other. So this is to make sure that the two versions are consistent with each other, and that's why we need to look at the English version as well. Legal advisor, anything else you'd like to add to that? So this is only about consistency. I don't have any further points. Any comments from members? No? Then perhaps we can now move on to Clause 4. Thank you. Clause 4, we are proposing to amend Clause 4D in response to members made by members and the ALA. That is to expand the scope of the clause so that non-compliance with a notice given under Clause 21, bracket 2, and non-compliance with summons under Clauses 24.1b and 36.1b would constitute a disciplinary offense. So failure to comply would be an offense. Thank you. So do members have any comments on this amendment? If not, as agreed earlier, we may now adjourn here, and to allow members and the administration so in respect, so the administration can take a look at the proposed amendment to see whether or not there's anything which has been left out, so that we can look at them at the next meeting. The next meeting will be held on November the 10th, a Tuesday, at 2:30. So if members have no further points to bring up, I declare that the meeting is now adjourned. Thank you very much.